All right, good morning. I'm Juliet Kostritsky, and I have been teaching for 33 years at Case Western Law School. I specialize in contracts, but also teach payment systems and sales, business and law, and advanced contracts. And before that, I practiced in New York at Milbank, Tweed, Hadley, and McCloy. So anyway, but today, I'm going to talk about framework contracts that are also known as long-term agreements, LTAs, or master supply agreements. So one caveat, I'm just starting on this project, and I have two projects going. One is really about the economics of framework contracts, and the other is empirical. When do companies use them? When do they not use them? When do they avoid them? And so I'm actually going to be doing interviews, qualitative interviews. I've already started, and then I'm going to conduct a large survey, and I'm working on the survey questions now of industrial sales companies. So if you have any connection with framework contracts, I would love to hear from you. And my email is jpk3@case.edu. I'm happy to send you the paper when I'm finished. I'm happy to send you any sources you're interested in that I refer to today. I would love to be in contact with you. Okay, so first, terms, terminology that we're just going to need during the course of the talk. First of all, I'm going to refer to a buyer or an assembler or a customer who also might be a manufacturer. They could be an original equipment manufacturer, sometimes referred to as an OEM. Could be an automaker or an airplane maker. Okay, so that's the buyer, the supplier or the manufacturer, the seller is going to be producing items that they're going to sell to the OEM or to the buyer. And they may be part of a network, a supply chain. It's been defined by Sue Helper at Weatherhead as a network of firms involved in designing, producing inputs for assembling and distributing a good. Okay, so today, I want to talk about what's new in framework contracts and what's durable, what has been around for a long time. So these LTAs govern the exchange of goods in the supply chain. And recently, scholars have heralded these LTAs as a new way of selling goods. Now, although they've existed for decades, the nature of these agreements looks different today. The parties' problems, however, in exchanging goods are durable. They're constant. So this essay is going to, or this talk is going to examine what's new in these agreements, but I'm going to argue that we can even learn more if we look at what's durable in terms of what are the problems that parties face and suggest that the new practices in these LTAs represent new ways of solving what are very old problems. So how are these framework contracts new? Well, they're new in some ways because they're tied to the new production economy and the de-verticalization of buyers. So in the early 20th century, the vertically integrated firm like Ford Motor Company outsourced very little production. And that was in part because there was a concern that if they bought significant custom items from external suppliers, there was the possibility that those external suppliers would hold them up. So that if Fisher Body produced a door that GM really needed and they were into the supply arrangement, then Fisher Body could say, well, we want to demand a lot more money for the door. So in some ways, a response to that possibility of holdup was that firms vertically integrated as a way of solving this holdup problem. Now, in today's economy, buyers, because of increased need to innovate and to collaborate in an intensive and creative way with external suppliers, think pharmaceuticals or new airplanes, these external suppliers are playing a really pivotal role. And why would that be? Well, in some ways it gives the firm the opportunity to harness the expertise of external suppliers without having to develop all that expertise internally. So that is the connection to the new economy. These external suppliers are playing a more pivotal role, and the reason is that buyers are depending on them to play a more pivotal role, to have more expertise that the buyer can utilize and then save itself the cost of having to do all of that itself. Okay, so that's what's new. So what's durable in these exchanges? Well, regardless of how deep or how shallow the need for collaboration is with the external supplier, the parties are going to face a variety of problems that they need to control in an efficient manner. And the real question for any analyst looking at the supply chain is how the particular arrangements adopted by the parties are going to solve problems of uncertainty and opportunism that are endemic in all exchange relationships. How do these arrangements that we're going to be talking about today achieve the parties' goals of getting high-quality goods to the buyer while generating fewer benefits from cheating or shading or shirking? Now, solving those problems by an enforceable contract is going to be difficult. It's going to be difficult to specify all the contractual obligations in a world that's very uncertain. You don't even know when you start the arrangement what the product will be if you're in a biotech arrangement with big pharma. So there are lots of uncertainties. So contract may present certain challenges in terms of solving these problems. Okay, so one response to the problems of uncertainty about the reliability of your counterparty, is there going to be opportunistic behavior, and about the competence of the other party, is the LTA. The LTA, the long-term arrangement, or the MSA, may be one means of solving these problems of uncertainty and opportunism. One thing to keep in mind is that the way these agreements operate is primarily or largely through sharing information with the other party. So there are information sharing protocols that I'm going to get to. And in a way, they promote collaboration, they promote transparency, and they promote trust in the other party. There's kind of a learning by monitoring. As they become enmeshed in this relationship, they learn a lot about the other party. So the LTA, by having these kinds of mechanisms of information transfer, is responding to some of the problems of opportunism and uncertainty. So it may be one solution to some of the contractual difficulties that I alluded to earlier. We can't solve everything by contract. We can implement the LTA, which is a formal agreement, but has all of these information protocol transfer arrangements that promote a kind of informal governance between the parties. And so this may be a possible solution, one possible solution. But one thing to keep in mind is that these problems that I discussed earlier of opportunism, uncertainty about the competence of the other party, people in the supply chain, parties in the supply chain, have multiple ways of arranging how they're going to exchange goods. The LTA or the MSA is one mechanism they have, but parties may deliberately opt for other ways of exchanging goods. And so I'm going to talk about those today. So from talking to people in the industry, what I'm finding is that beyond the LTA, parties are sometimes operating simply purchase order by purchase order. They're operating as a contract manufacturer and limiting liability by simply executing a blueprint without any deviation at all from the blueprint. Or entering into a joint development project with another party, but foregoing an LTA and choosing deliberately to rely solely on protection through intellectual property and licensing mechanisms. So one thing that I want to just emphasize is that the parties making these decisions are doing so deliberately. Am I going to opt for an LTA? Do I have any choice? Maybe the OEM doesn't give me a choice and says I have to sign the LTA. But if I have a choice and I can resist that, I might choose to operate in this other fashion, and I'll talk about why and when that would be the case. So today we're going to talk about these other arrangements in addition to the LTAs, and then I'm going to ask if informal enforcement is an important part of all of these arrangements, and it is, because parties rarely invoke the law. They go to the law as a last resort. If there's a quality problem, they're going to work it out with their customer, and the buyer will work it out with the supplier. What is the role for legal enforcement? When should legal enforcement be invoked or be awarded? What kind of remedial scheme is appropriate? It squarely raises the question that the contract scholar Stuart McCauley from Wisconsin raised when he asked this question: why does business ever use contract in light of its success without it? Okay, so finally, in the introduction, I want to talk about two other issues I'm going to address in the talk, and that is the idea of failures. So I'm talking about the LTAs and their information sharing protocols and how they may promote informal enforcement and extra contractual governance, but in some instances there may be failures of these information sharing protocols. And parties may, in the words of Josh Whitford, who's a scholar in the area, may start to hedge. They may not be forthcoming about the information to the other party because they fear that the other party will opportunistically use information that's shared in a variety of ways that are negative, for example, to the supplier. And all of these issues of what kinds of arrangements, how much does the law play a role, should play a role, what kind of contractual obstacles do parties face, what kind of failures can you anticipate, all of that will play an important role in the kind of advice you give to clients in these complex supply chain networks. One point that you want to make is that these supply chains are not uniform. In other words, we have different ways of organizing the supply chain of goods, and they're not always successful. And what you want to do is reduce these various hazards, alert your client to what the risks are in different arrangements, and so forth. Okay, so before we get into supply contracts, I want to talk about some of the constraints on contracting. And this is important because in a supply chain arrangement, you are entering into a formal agreement, but there are all kinds of difficulties that these parties face in finalizing their agreement and having it cover all possible contingencies. So one big obstacle in these arrangements in terms of contract is there's uncertainty about the actual product that's going to be produced or purchased. That would be particularly true in a pharmaceutical venture between a big pharma buyer and a small biotech company. So you don't actually know what the product will be when you start, or whether in fact there really will be a product. But it would also be true where the buyer, the customer, anticipates that the supplier is going to make incremental improvements to the product, so that there may be a purchase obligation in the beginning that's firm, and then there may be an uncertain obligation going forward, or one that's qualified or really illusory when the improvement to the product is not yet developed. But anyway, all of those uncertainties about the nature of the product are going to interfere with being able to describe the product with sufficient certainty for definite contractual enforcement. Okay, so that's one contractual obstacle. Another contractual obstacle that parties face in supply chains are forms of asymmetric information. So in the beginning, the buyer may not be clear about what type of supplier they're dealing with. The supplier has superior information about that issue. The supplier knows whether it is going to be a good supplier and whether it will supply high-quality products, but the buyer doesn't know how good the supplier will be. And so that's a problem of asymmetric information, or something that's called adverse selection in the world of economic contracting. And this is a term that's also used to describe the problem in insurance when the insured knows more about its risks than the insurer does. And so, anyway, the buyer faces that problem. And in a way, that asymmetric information is a form of opportunism, because the supplier, if they're not a really good supplier, will try to hide that information from the buyer. But buyers also face another kind of uncertainty, and that's uncertainty about how the supplier will act in the future over the course of the supply chain. Will the supplier produce high-quality goods with a low defect rate that meets the customer's standards? Or will the supplier shirk and produce inferior goods? This is essentially the risk of shirking or shading, and it's the same kind of risk that a principal faces when they hire an agent. You don't know, as the principal, how your agent will behave in the future. There's a kind of behavioral uncertainty. Will they exert the maximum effort for the principal, or will they, in fact, shirk and divert some of their energies to their own sort of self-promotion that really, in ways that don't redound to the benefit of the principal? So these costs that I'm just describing now, that take the form of asymmetric information or behavioral uncertainty about how the supplier is going to act during the course of the arrangement in terms of the goods, are particularly troublesome for a modern buyer in this new production economy. A buyer, assembler, OEM today is under great pressure to meet just-in-time production. So the legal remedies of rejecting goods, asking for a cure, and then suing the supplier in court if the cure is not made are just too costly. They're unsatisfactory as a remedy. So buyers face uncertainty, and so this is something that you want to keep in mind when you're talking about what kind of arrangement these two parties are going to enter into. You see all of these problems that are affecting the buyer. He doesn't know how good the supplier is in the beginning. He doesn't know how forthcoming he'll be in the future with information and with quality. But there's also the supplier has the problem that they could invest significant sunk costs in tooling or capital equipment for the buyer, which can only be recouped by amortizing the cost over a long-term supply arrangement. And there's the possibility, the potential, that the buyer will renege on a purchase commitment. So that's a kind of opportunism by the buyer that confronts the supplier. And what else does the supplier face? Well, the suppliers face the risk that the buyer will claim falsely that the products are defective when they're not. And the supplier faces other kinds of opportunism if, for example, the sharing of information by the supplier results in the buyer, the OEM, giving that information to the supplier's competitors or using that information to manufacture an item in-house on the basis of the supplier's blueprints or information or something like that. So those are the kind of problems that the parties in these supply chains face. Opportunism on both sides. Okay, so what do they do? Well, one of the things that they do is they might enter into an LTA and MSA, And one thing you want to keep in mind is, or that you need to worry about is, are they legally enforceable documents? So there is no one answer on the legal enforceability of LTAs in general. The particular document is going to determine enforceability. If the LTA does not contain a quantity term, and it's not a requirements contract, the general view is that the agreement ex ante will be unenforceable since it lacks a critical quantity term necessary under the UCC. Of course, and that means that until the first purchase order is made, there is a risk that the buyer could refuse to make any purchases under the agreement because, as entered into, it is an unenforceable obligation since it lacks a quantity term. And the supplier remains vulnerable to that risk. Of course, once the first purchase order is made and the quantity is then defined in the purchase order, the purchase order is effective as a legal obligation for that quantity. And the purchase order may, in fact, and often does, incorporate by reference the LTA in terms of the purchase order. But, so you solve the legal enforceability problem with the first purchase order. But in terms of commitments going forward, as a continuing obligation, is it a legal obligation going into the future, obligating the buyer to continue to make purchases under the agreement? That really depends on the nature of the agreement, because in some instances the LTAs may commit only to provide forecasts to the supplier of what their anticipated buy needs are. And they may disclaim any obligation to purchase any goods in the future made by the supplier. Some may be not quite as draconian for the supplier as that, and they may make future purchase obligations dependent on the supplier continuing to meet the quality requirements that the buyer is imposing or price competitive requirements that the buyer is imposing. So, so it won't be completely illusory. It won't disclaim an obligation to purchase, but it'll make the obligation to purchase contingent on these other aspects that the supplier is somewhat in control of, like remaining price competitive and maintaining high quality. Okay. So if some of these LTAs, at least ex ante, initially are legally unenforceable and may be legally unenforceable going into the future in terms of a future purchase obligation if it makes it illusory or qualified or contingent, why would parties enter into these kinds of agreements? So the first answer is the one that harks back to what I talked about before, which is once the first purchase order is made, it becomes a legally enforceable document. And in some ways, this may solve a lot of the problems because the supplier, what may be most important to the supplier, what is possible depending on whether that supplier produces a fungible good or one that's more customizable. But what may be most important to the supplier are provisions in the MSA that limit damages, that cap damages, that eliminate consequential damages, that limit warranties, or that indemnify the supplier against improper use of the product. So if that's the case, in other words, my question was, well, why do parties enter into these agreements if, at least initially, they're unenforceable? So part of the answer is, well, once the first purchase order is issued, it becomes legally enforceable. And if what the supplier cares about are really these provisions that cap damages, well, then they will be protected because once the first purchase order is issued, and if there is something that goes awry with the product, and there's a claim against the supplier, what the supplier really cares about are the damage caps. And those will be operative, because once the first purchase order is issued, the cap will be in there, and that's what they really care about. So that may be one answer, one explanation for, well, why would parties enter into these legally unenforceable agreements? The second answer is that, at least in some contexts, it's thought that these LTAs, these MSAs, offer security to suppliers. So in some contexts, like the automotive supply industry context, the automotive suppliers are not going to enter into purchase order by purchase order arrangements. They want the security, whatever qualified security exists with an LTA, they want the security of having a long-term arrangement, even with the limitations that I've described, that it might be contingent on. Yeah?
This is just so I understand the rest of it. When you have an LTA, MSA, is the purchase order for that kind of arrangement just a simple thing that just says, here's how much, and we incorporate everything from the other agreements?
Well, it might. Okay, the answer is it depends, I think, because sometimes the purchase order will actually have more provisions in it, and there may be then a provision in the purchase order and or the LTA about the hierarchy and precedence of which document governs and which has preference, and there may be a hierarchy between the MSA and the purchase order, and the terms and conditions which are available on the web for a company and so forth. Okay, so the two, why do parties enter into these arrangements? One, they care about the provisions like damage caps that are going to be operative once the purchase order is issued. And the other is some automotive suppliers, for example, parties who have very large upfront investments, who can only recoup those investments if they're amortized over a long period of time, are going to be unwilling to enter into arrangements that are simply purchase order by purchase order. If you're manufacturing, mirrors for a automotive company, it may be that you have to actually build a plant in order to formulate these mirrors or various other doors or some other product. And this is a huge capital investment. So you're going to be unwilling to operate just purchase order by purchase order. And even with the kinds of limitations that I described, of qualifying, the limitations being that the buyer might qualify its obligation to purchase based on the quality of the product, that it has to be good or otherwise the buyer won't buy it. Well, the supplier can think to himself that those are things I can control. I can remain price competitive. I can produce a good product. And therefore, even if the buyer makes its purchase obligation contingent, it won't matter because I'll be able to meet the contingencies, and therefore it will, in fact, offer me security for a purchase obligation going forward. And the other thing that happens is that there may be a kind of implicit trust that builds up that may constrain a buyer from terminating, even if it has the legal ability to do so. So once you're in an LTA, that this implicit trust may, in fact, constrain the discretion of the buyer. And there are examples where, in the automotive industry, where the buyer was going to buy a rear view mirror from a particular company, and then because that didn't work out, they helped that company retool to produce side view mirrors. So there are all kinds of implicit kind of help that might arise from the arrangement once it's in place. So those are two answers as to why parties would enter into these agreements even if they weren't legally enforceable from the beginning. Now, I've alluded to some of the benefits of sort of an informal, extra-contractual governance that comes about once you enter into an LTA. And so now I'm going to talk about the other benefits of LTAs, and that is what is the informal governance that I've been talking about? And how does it come about? And then later on I'll talk about, does that mean that we don't resort to the law ever? No, but what are the mechanisms in these LTAs that promote informal, extra-contractual governance? So essentially, the LTAs have these information sharing protocols, and they are extensive. So the supplier has to furnish quality control reports. They have to engage in quality training programs. They may have to participate in webinar training to become an excellent supplier. The buyer's obligation to purchase may be dependent on the buyer meeting the standards in the quality control manual. The buyer may incentivize the supplier to become an excellent supplier by having a graduated kind of step program for the supplier, so that ultimately it starts out being a lowly supplier, and in the end it becomes a partner of John Deere. And how does that happen? So it happens by the supplier being willing to supply quite a lot of information to the buyer. And the result of that is that the parties learn quite a bit about each other and about the competence and reliability of the other person. So that is kind of what some scholars refer to as a braiding mechanism. These are informal mechanisms, and they operate in the context of an LTA, and they encourage parties to continue to deal with each other. It also, these provisions in the LTA also promote a lot of self-help on the part of the buyer. I was really struck by reading some of these, because instead of having to, and especially because I teach sales and deal with cure and rejection and revocation of acceptance and all of that. So the provisions in a lot of these agreements permit a lot of self-help on the part of the buyer. So instead of having to reject goods that are substandard and then suing the supplier, the buyers aren't obligated to buy the goods that did not meet their standards, because the whole obligation to buy was contingent on the buyer meeting the quality threshold. So that gives the buyer a lot of control in terms of self-help. So these are some of the benefits of these arrangements. I just can't believe what time it is. Okay, so what other benefits? Well, they promote personal ties. They bind the parties together in this kind of personal way that you would think would be just strange. But what happens is, if the supplier has to go to the buyer's plant and spend time there, or if there's a quality engineer that is from the supplier that spends time at the buyer, or if they're sort of get-togethers between suppliers and buyers that John Deere arranges, for example, or even conferences in which suppliers themselves of John Deere get together, for example, and exchange information, that does tend to promote personal ties. Okay, so another benefit of these arrangements, another benefit is essentially that as they become locked into this arrangement, both parties are sort of deterred from exiting. And this is called, by Bob Scott from Columbia, a switching cost. And what happens is both parties become reluctant to exit, and that constrains opportunism by both parties. So, for example, the buyer doesn't want to terminate the supplier without having good reason to do so. Because why? It will have to explain to a new supplier why it terminated this supplier. And that supplier will want to know the real story. And similarly, if the supplier terminates a relationship with the buyer, it's going to have to explain to new buyers why it did that, and maybe it's not trustworthy and all of that. Okay, all right. So the LTA, all the benefits, right? We just went through them, and it's a braiding mechanism. It deters opportunism by both parties. But keep in mind that it's not the only way to operate. So I started out with an LTA without a quantity requirement in it. But there are other ways of operating, and I just want to go through them quickly because parties, I think, do this deliberately. They know that they have an option as to how they're going to operate. Maybe their OEM tells them, you are going to sign this supply agreement, or we're not doing business with you. But if that's not the case, then just think about some of the options because it may affect how you deal with a client. Okay, so one option is instead of entering into an LTA without a quantity requirement, some parties might insist on an LTA that contains a quantity requirement, which would make it legally enforceable from the get-go. And a supplier may insist on that arrangement because they are worried that if they have a large piece of capital equipment or tooling costs, they want either an exit termination fee or a minimum quantity requirement, because otherwise they're going to be vulnerable to the pullout before they can recoup the cost of the capital equipment. So that may be another alternative. You enter an LTA, but you have a minimum quantity requirement. That protects you. You forego an LTA altogether. For example, one general counsel told me, for a 3D one-time printing order, a firm may forego an LTA and just have a purchase agreement. And the only risk then is the supplier who formulates the 3D printing equipment won't get paid for that item. But that's not a very big risk, and you have to weigh that risk against the cost of negotiating an LTA, which may have some other onerous provisions that you don't want to sign. So another way of operating, and I'll talk about three more, is purchase order by purchase order. And some suppliers deliberately choose to operate purchase order by purchase order and deliberately choose not to enter into an LTA. In the way it was described to me, the supplier can insert terms that are favorable to it in the purchase order with the hope that they will govern, and they really care about warranty, damages, liability, insurance, indemnity, and IP. And they think that they can manipulate the purchase order or the acknowledgement form in a way that gets them to where they need to go. Why would a firm do that? Well, as the asymmetric investments or large sunk costs are absent in cases where they're not there, then the supplier may decide that if we're only manufacturing fungible goods, we don't want to undertake the cost of an LTA. If, for example, the supplier produces most of its products from a catalog and the buyers buy from a catalog, they think purchase order by purchase order may be sufficient protection for it in a way that would not be the case if you had an automotive supplier building a plant to manufacture a product for the buyer. Then you don't want to operate purchase order by purchase order. You can also, as a supplier, operate as a contract manufacturer so that you take the blueprints, for example, of a medical device company, but you refuse to put your insignia, the supplier's insignia, on the print or to deviate from the blueprint in any way in order to limit your liability. So the liability exposure on medical devices is obviously huge, and the supplier who's manufacturing a medical device or participating in the manufacture of a medical device for another company may want to simply act as a contract manufacturer and limit its role in that way, and will deliberately not enter into an LTA and will just execute the blueprint. The last way of operating is by essentially IP licensing. You could jointly develop a product, and of course, it will be impossible to describe the product to begin with because you don't know what it is yet exactly. It's joint development. So you negotiate IP ownership rights and licensing arrangements, and that may be enough to protect you. You can do that by having an option on the IP and the licensing. Of course, there are issues that might arise that you want to alert your client to. How can one party protect yourself when the other party isn't sufficiently investing in the joint development aspects? Okay. Now, I have to speed up, but I want to talk about networks just a bit, because I talked about earlier the fact that there's a lot of informal governance and self-help going on that's generated or prompted by the kinds of information sharing protocols that exist in LTAs. But one thing to keep in mind is that regardless of the arrangement that you have, whether you enter into an LTA or whether you operate purchase order by purchase order, whether you operate as a contract manufacturer, there are always ways that parties are going to have to try to sort of jawbone the other party, informally sanction them for misbehavior or for not living up to the standards or something like that. And that can go on across the board. The thing about the LTAs is that they generate a lot more information that can be used to sanction the other party. Because of the transparency of the information that's being generated, it gives you more points of reference to say, well, but you're not living up to this. You're not allowing inspection at your plant or something like that. So in terms of these informal mechanisms, if you all belong to a very close-knit group, informal sanctions against the other party would be fairly easy because everybody would know each other. The diamond industry in New York is kind of a prime example of that, and Lisa Bernstein from the University of Chicago has studied how information is all transmitted among these diamond dealers, and it's all extra legal. The sanctions are all extra legal. You become a pariah in the diamond industry if you do anything that is not what you should be doing in terms of quality. And so in a small environment like that, lots of informal sanctions can easily take place. But even in a more impersonal, heterogeneous situation like we have in the supply chains, what we find is that if you're part of a network, and they can be defined, and you can pick this handout afterwards, it is a network. If you're part of a network that has suppliers and OEMs or buyers, and you have centrality in that network, and there are not many intermediaries between you and another buyer or you and another supplier, information can generate or can transfer in that network pretty readily. And it turns out so one thing to keep in mind, if you're ever advising a client, is to figure out what where do they play in this network? Because if they're not going to insist on suing the other party, it may be important that they're part of a network that has lots of interconnections, because then they can complain about the other party in ways that will have significant effects. And one thing I want to talk about in terms of network effects is it turns out in the biotech industry, being part of a network is so important that it could act as a substitute for something that you would ordinarily take to protect yourself, but you don't need to take to protect yourself if you're part of a network. So in the biotech industry, for example, if you're worried about how the founder is going to operate the company, and you're worried about how they're going to shirk and all of that, they'll self-promote, but they won't do the product properly. You could take an equity participation, but it turns out that if that biotech company is really very, as Lisa Bernstein said, deeply embedded in a network, then there is a lesser need to assume an equity position. And so being part of a network can be really huge. Okay, let me talk about a couple other topics. One is failure of networks. Why do we care about it? And how it might affect your role as a lawyer. Okay, and advice to clients. So I talked about it earlier. and maybe the idea of failure is sort of understudied, but it's really important because not all networks operate in this wonderful, virtuous way in which there's this sharing of information and it helps parties innovate and they collaborate. That's the ideal network. But in reality, there can be a lot of bumps in the road. And one of them is the virtuous circle doesn't operate because the buyer starts utilizing the information that the supplier has supplied to keep pressing them on cost reductions when in fact they're no longer feasible or they're cutting into the supplier's margin. Or they take it in-house and they expropriate that information and they cut the buyer out. So that's a problem. So when you're thinking about, we're going to enter into this LTA and it will be very great and nobody will shirk and there'll be all kinds of switching costs if you leave it, and that's the ideal. But in fact, there can be huge failures, one of which was the Boeing Dreamliner failure. The idea of Boeing was to cut cost and to outsource a lot more. They relied on 50 Tier 1 suppliers who had then had Tier 2 suppliers and Tier 3 suppliers, and there were enormous problems in terms of delay and quality, Boeing didn't provide the kind of on-site inspection that was necessary to make the LTA work, to make the agreement work, and so there was a colossal failure. So one thing you want to think about is not all frameworks are successful, and you have to be aware of that. Okay, so advice to clients. I think one thing you want to talk about is the success or failure of frameworks is something you have to keep in mind. And that may mean that if you're advising a supplier, you may want to tell the supplier that it may not work out if there are not reciprocal investments by the buyer. So if you were advising a supplier in the Boeing case, of course, it's all hindsight now because we see that there were many failures. But you could have said, look, Boeing is not doing a lot of things that are necessary to make this work. They instituted a computer system for communicating, which displaced all people. Well, that really led to problems. And so it was called ExoStar. So one thing you want to alert your supplier to is, if the buyer is not making kind of large reciprocal investments that will deter them from exiting, you have to worry about that. John Deere seems to invest quite a bit in terms of their own commitment to the supplier, so that they are expending a lot in order to make this network work. So if you can have that kind of situation, your client will come out better. So alerting them to that is kind of an important thing. And finally, in terms of non-legal advice, and this seems like a strange thing, but it came up in an interview with someone, and that was maybe the best advice or one of the great advice to a supplier is to develop a unique product. It's not a piece of legal advice, but if the supplier can have a unique product, they can resist a lot of the pressures that will be put on them by OEMs and so forth, because it will be harder to shop whatever it is at auction. And that will put the supplier in a better bargaining position and so forth. Okay, I'm sorry I went over. And now it's time for questions. Yes?
I'm assuming that you're speaking about contracts existing in a global economy. How do you see the shifting U.S. policies affecting current contracts, and do you anticipate unique provisions in future contracts?
So on U.S. trade policy and how it's going to affect these supply contracts, I know that I'd say it's a complicating factor. When I was reading about the problems with the Boeing Dreamliner, one of the factors that management scholars cited as a problem in the Boeing Dreamliner situation was a lot of outsourcing overseas. And although theoretically it's possible that you can solve those problems by developing coordination mechanisms to take account of that, I think it will be a complicating factor. But in terms of how trade is going to be shut down, I don't know what to say about that. I'm not an expert on trade. But I think there will be complications in the contracts. Yeah. Yeah.
You had this huge Tanaka airbag mess.
Yeah.
Did they have one of these, and how did that work out?
I would assume they would, but after this discussion, I'm going to go look for it and see if I can find evidence of a Tanaka agreement. If you, one great thing, and you probably all know about it, but if you're a public company, you have to file important contract documents that are material with the SEC, and the Edgar SEC database allows you to access a lot of these agreements. So it's a great way to research. So I'm going to go look for Tanaka. Thank you. Yes. Charlie Manick.
Yes.
Hi.
Hi. I was wondering, do Incoterms address any of these issues? International commercial terms that are basically, back since the 1920s, they've been around, and it's more civil jurisdictions usually refer to them more than maybe we do over here. But
so these Incoterms, are they incorporated into these LTAs? Is that what you're asking?
It's an organization that has formulated. It's kind of a big think tank, and it's more. I've seen them more in Europe than I have over here.
So I'm not that familiar with that.
I'm actually not either, and that's why I'm asking about it.
But I know
I know the term.
Okay, so I'll look for that. I know that in some of these LTAs and MSAs, they do incorporate ISO terms. So there are quality standards of an international type. So in addition to John Deere's excellence, you have to meet the excellence manual, they also incorporate these ISO terms so that you have to meet international quality standards in order for the buyer to be obligated to buy or whatever. But I don't know about the Incoterms. And do they deal with quality?
It's basically kind of an international UCC, sort of.
Right, but we often make that not apply, I think.
Okay.
Right, I think that U.S. companies often opt out.
But I'm just wondering if they might address some of these issues.
Oh, yeah, I'm going to look. That's great.
All right.
So again, if you want an article on the Boeing Dreamliner fiasco, or Lisa Bernstein's article on kind of network governance, and here's her little illustration, it's really fascinating, or any of these other sources I cited, I'd be happy to send them on. We can have an ongoing discussion. All right, well. Thank you for coming.